So the court...
But that's because of the choices your client made.
Well, I think that the first issue that I would address is that in post-conviction, we had an expert look back over the records, and she said she would not have found him competent to represent himself. And I do want to point out that in the examination that was done at the trial level, pre-trial, Dr. Meyer wrote that she defers to the court to determine his competence.
A death row inmate who represented himself at trial now argues the court should have never allowed it. Scott D. Allen refused lawyers, declined to present mitigation, and even expressed a desire to be sentenced to death. Now his attorney claims that that decision was driven by severe PTSD, a mental illness, not a rational choice. Florida Supreme Court Justice pressed both sides in a tense debate over personal autonomy, competency, and the death penalty.
From a legal standpoint, given his intended defense or lack thereof. And the doctor also acknowledged that it was sort of an issue that Mr. Allen wanted to be sentenced to death, did not plan to challenge the evidence or present any sort of mitigation. Now, one of the criteria for being competent is their ability to present a defense, or if it's competency to proceed, their ability to assist counsel in presenting a defense. And what the expert in post-conviction found is that there's a direct link between Mr. Allen's mental illness of PTSD and his inability to present mitigation. She touched on, in our expert's report, she touched on defensive avoidance, which is when someone tries to avoid situations which would cause them to re-experience their trauma, and intrusive experiences, which is when that happens and you're re-experiencing your trauma because of the situation that you're currently in. By not having an attorney and not having his family called to testify to mitigation, Mr. Allen was actively avoiding reconfronting this trauma that's very much linked to his PTSD.
Let's stipulate that all of that is true. Is your position that Mr. Allen doesn't have the right to waive that presentation?
I think given his mental illness, it would have to be presented in some other form if he was sort of deemed, I don't know.
Do you take issue with the trial court's sustained, I want to say multi-year, but it may not be, multi-year colloquies, the Feretta inquiry? I'm looking at December 20th, 2018, February 6th, 2019. There's an expert appointed to evaluate him in December 2018. Is all of that for naught? I mean, it seems like the trial court went to pretty considerable lengths.
And I would say that Mr. Allen was very clear on his intentions of wanting to represent himself, not wanting counsel, and that he wanted to be sentenced to death. But what I think is missing is the link between this idea that he wants to be sentenced to death and he wants to waive mitigation and the PTSD, which the court subsequently became aware of when the mitigation was presented. But the doctor at the pretrial level never made that link somehow between...
Is your argument that the Feretta inquiry in this case was flawed?
No, I don't think that there's a problem with the Feretta inquiry. I think that the main issue is that the court did not heed Dr. Meyer's advisement that she was going to defer to the court from a legal standpoint, that this guy isn't going to present a defense. That looks kind of like he's...
I'm sorry, and did the court lack discretion to do that? Was that an abuse of the court's discretion?
I think that the court doesn't have the knowledge of PTSD and the way it interacts with someone's decision-making.
So is that a yes or a no? Is it an abuse of discretion or not?
I guess we'll say yes, it's an abuse of discretion because he should have relied more heavily on a psychological expert. Additionally, in post-conviction, that same expert opines that even Mr. Allen's desire to be sentenced to death is a result of his PTSD in attempting to control his situation and be somewhere where he's, not exposed to as many stressors as in general population. And again, that was really the the missing link that the trial court did not have, and that's now been developed. And so I guess the argument about it being procedurally barred is that there's this information that has been developed in post-conviction that shows that what
all of
the court
that
did
results
was prejudicial.
from your client's choices. And I understand you're saying he wasn't in a position to make the choices, but we got expert testimony to the contrary. And it just seems like two different ways to look at this. Your client's trying to exercise some agency here in a difficult circumstance, on the essentially an indefensible case in terms of the guilt phase. Am I wrong?
Well, I would say that because of his self-representation, there were other serious omissions that should trouble this court. I mean, this was not an adversarial proceeding because Mr. Allen was helping himself to be.
But we have other proceedings that are not adversarial. For instance, when a defendant pleads guilty, okay, admits it. That's a legitimate thing. We don't say, oh, well, that's not adversarial. We're going to, even though he wants to plead guilty, we're going to go through some motions here to test whether to create an adversarial process in the face of a guilty plea. I mean, again, he chose what he wanted here.
I just think this court should have a real problem with someone getting sentenced to death, perhaps just because they want to be sentenced to death, not because of the evidence that's presented. As I was saying, the other omissions are troubling. Mr. Allen actively supplied the state with aggravating evidence for the purpose of being sentenced to death. There's also the unaddressed issue of the prosecutor in this case being a mayor of a municipality in the jurisdiction, which those are facts extrinsic to the record. But the jurors did say that they knew the state attorney, and normally a defense attorney would have done some more questioning about that. How do you know him? What do you know him as? There's also the issue of the prior violent felony that was used as an aggravator. There could have been some very substantial cross-examination on that because it's sort of what you're describing. It's doubtful.
You actually kind of get in the ballpark of arguing that the prior murder might actually have been mitigating?
Yes. Because it's doubtful whether
I thought I caught that.
Yeah. It's doubtful whether he committed that crime.
So how? Explain to me how it would be mitigating.
Well, so that was a plea of convenience that seems to have been taken to shield his girlfriend from criminal repercussions due to her involvements in that. And so I think that the fact that he may not be guilty of that.
Is there any case where we've said that circumstances surrounding a prior murder conviction are mitigating?
Well, I think that the jury could look at it as a chivalrous act, that he doesn't want his girlfriend who's pregnant with their child to be incarcerated, and that instead he's taking the rap for her. I think that some jurors could see that as a mitigating circumstance of the defendant's background. Additionally, it kind of diminishes the weight of that aggravator if the jury had been led to question whether he actually committed that or whether it was just a plea of convenience. And all of that investigation into the prior was done in post-conviction and was unknown to the jury and unknown to the trial court. Additionally, I think the elephant in the room, the court forbidding everyone to contact Mr. Allen's family. So historically, this court has concerns about defendants.
Well, now that was at the request of Mr. Allen, correct?
Again, as I think we have established, because you have to accept the facts from post-conviction as true since they were summarily denied, that was, again, a result of him not wanting to confront his family testifying about this past sexual trauma of his childhood. And Um, Sorry. Once Mr. Allen sort of indicated that he was going to limit the amount of mitigation. So historically, this court has issues with that, and Muhammad gives some guidance as to what trial courts can do, and the court followed that guidance in appointing special counsel and a mitigation investigator and ordering a comprehensive PSI. But then the court sort of circumvented the whole purpose of Muhammad in forbidding all of these people to contact the defendant's family, which would have been the source for all this mitigation that the court, it seemed, did want to hear in spite of Mr. Allen's wishes. And I think that's the whole point of having special counsel, is so that the court can be informed of mitigation that the defendant may or may not want presented.
Have we ever reversed because of a Muhammad error? Because the trial court did not do something under Muhammad?
I think that I don't believe you have. I would have to research that, and I could submit supplemental briefing. But I think the point here is that the court, it would have been one thing if the court was like, I'm not concerned about his lack of mitigation, but here the court had concerns, and that was the reason for him, appointing special counsel. So it really...
Well, it seems to me, if you look at what happened here, the court is trying to chart a careful course where the court gets access to mitigation, but the court also shows respect to your client and does not just say, well, you don't want us to talk to them, but we're going to talk to them anyway. And it seems like to me he's trying to be respectful of the autonomy of your client, while getting as much information as he can while respecting that autonomy. So I don't think the idea of denigrating the trial court for taking that approach seems to me to be misplaced.
I understand that the trial court was put in a very difficult position here, but it still stands that an individualized sentencing requires that the trial court hear mitigation in order to properly assess what the sentence should be. That they have to have some understanding of what mitigation is out there. I would point to this court's decision in Robinson, where you held that the trial court has a responsibility to weigh, to consider all available mitigation and weigh it. And I would point to Justice Periente's dissent in Spar, which we cited in our brief, just to kind of address the procedural bar argument again, that when it's not necessarily always error for the court to for the court to say that counsel can't contact the family. But in this case, it was prejudicial because the family had a wealth of mitigation that they would have come and testified to. And all we're asking here is for an evidentiary hearing so that the trial court can hear that and at that point can make factual determinations and assessments. There were also other outside factors besides the court's prohibition. There was the lack of JAC funding for due process providers, which special counsel cited in saying to present an effective penalty phase, you would really want all of these different experts, but we're unable to retain those currently. The abbreviated time frame, I think, also contributed.
Did anybody ask for a continuance to deal with that?
I believe.
There was a continuance given, but subsequently, did anyone say we need more time to work on getting what we need to get here? Wasn't the real problem the limitation that your client had placed on contacting people?
I think there are still other people that the experts, of course, could have been contacted. That wasn't part of what the court forbid. Additionally, I think the mitigation specialist testified that she normally would get school records, and she would have to go to Michigan to do that, and that was not done.
Thank you for watching this Florida Supreme Court oral argument. If you enjoyed courtroom discussion with real legal debates, consider subscribing for more full arguments and key moments from court across the countries. All footage comes from a public available court proceedings and is presented for educational and informational purposes.